Lecture 8, Part 5, British Practices as to Treaties. The British practices as to treaties is different from customary international law, is conditioned primarily by the constitutional principles governing the relations between executive and the parliament. The negotiation, signature and ratification of treaties are matters belonging to the prerogative powers of the crown. On the other hand, the customary practices about customary rule are different, as we discussed in previous lecture, in previous sitting. Treaties which require the approval of parliament. There are 4 to 5 kind of treaties which require explicitly the approval of parliament. First one, the treaties that affect the private rights of British subjects. Second one, the treaties involve any modification of common or statute law by virtue of their provision or otherwise. Third, treaties that requires vesting of additional powers in the crown. And fourth, treaties that international treaties that impose additional financial obligations direct or contingent upon the government of Great Britain. All the above referred treaties must receive parliamentary assent through an enabling act of parliament, and if necessary, a legislation to effect the requisite changes in the law must be passed. Second, the treaties made expressly subject to approval of parliament, the approval may be given in the form of statute or by resolution. In addition to 4 kinds already mentioned, if in a treaties, international treaties between Britain or an other country or an international institute that it should be approved by parliament, then the same put before parliament and be given or be ratified through statute or by resolution. And last, the treaties involving cession of British territory require the approval of parliament given by the statute. Thank you very much, and in the next vlog we shall discuss American practices regarding customary rules.